All right, so we do have a update on the limited partner exception dealing with the Soroban case in the Second Circuit. For those of us in the Fifth Circuit, we had the Sirius case, which was taxpayer friendly, but there's the Soroban case that is untaxpayer friendly. They looked at a limited partner exception and said it doesn't apply. You have to apply a functional test. So even though the statute allows for limited partners not being subject to self-employment tax, in this case, the managers of the fund were held liable for self-employment tax, and so they're appealing that. And they're saying that you really should be looking to the Sirius case and not applying a functional test. And then also they're making an argument that the partnership cannot determine the self-employment tax liability of the partners. That's a partner level item. And so the partnerships the courts have overstated the partnership's ability to do that. So that case is on appeal right now. They had oral arguments with the judge last week, the panel of 3 judges. It does not look good for taxpayers based on what the judges have said. The judges all asked for the IRS to rule in this case because the only favorable part of this is they don't want to have a split between the Second Circuit and the Fifth Circuit, but none of them agree that anything other than filing or applying the functional test. They all were arguing that a limited partner is limited to what they can talk about and deal with in management. It's truly a limited partner. At one point, they even talked to the defense counsel and said, come on, you learned in law school what a limited partner is, and that means you weren't very involved in the business. So not looking good for taxpayers, at least in the Second Circuit. Prediction right now from certain commentators is that the Second Circuit will upheld the ruling of the IRS and treat these partners as subject to self-employment tax, and then we'll just have a split between the Second and the Fifth. And then they're just going to continue to push on Treasury and the IRS to change their rules to make limited partners further defined, so we're not dealing with it. The courts also were very concerned that they made a comment that in this case it's very clear that the managers should be subject to self-employment tax in their opinion. But they said once you set that, then you have a slippery slope because somebody else may not be as close there. So they are worried about the ramifications and they are worried about the split circuit, but it's not looking very taxpayer friendly right now.